Good morning, and we will reconvene the hearing looking at natural hazards. The intent this morning is that we will hear from the Telco Companies and Alliance. And I think that we've got Tom online. Good morning, Tom. Welcome. We have had a read through of your evidence, but if you just give us a brief overview, and there might be some questions that followed. Have you seen the supplementary evidence that was lodged and some further changes recommended?
Yes, I have.
Okay.
Yes, so maybe that's a good starting point. Well, I'll give a quick précis of my evidence and move on to that supplementary statement, and then, yeah, happy for any questions.
Thank you.
So essentially there's one limited submission point which sought an exclusion for telecommunications infrastructure from the natural hazards chapter, and that was based on Regulation 57 of the National Environmental Standards for Telecommunications Facilities, which exempts regulated activities under that NES from complying with natural hazard rules in a district plan. There is the only telecommunications activity which therefore is not governed by the NES the placement of poles on sites outside of road reserve in urban areas. So it's quite a niche sort of exemption, if you like. So, and the reason for that was the NES decided, when it was being written, it was decided that poles should always be governed by district councils so they can regulate the height of the pole and that amenity effect that occurs, which is why it was excluded from the NES. In those private sites in urban zones, everywhere else they are a regulated activity. Regulation 57 of the NES exempts the regulated activities from complying with natural hazard rules and district plans, and simply what I was seeking through my evidence was that that same exemption is passed over into the district plan for that pole situation I've just outlined. I know Mr. Osborne, who has been very thorough and very good to work with during the last couple of weeks as he's been preparing that supplementary statement, we've discussed it a number of times, and Mr. Morris, who I see online as well, has provided some evidence around it which agrees with that point, namely that the telecommunications infrastructure, the poles, have a very small footprint and therefore unlikely to have a noticeable or any significant effect on natural hazards if they're located in natural hazard areas. So I agree with the recommendation and supplementary evidence of Mr. Osborne, and happy to answer any questions.
Are you aware of any telco facilities that are within hazard areas on private land in Gore?
Yes. Yes, I am.
So are there many?
Not in the Gore district, but in other places.
Right.
I'm aware of it.
Now, yep, go on.
I was just going to say, when we're on site looking for new telecommunication facility locations, the best practice and what is always the first sort of thing to do is to avoid those natural hazard areas, but that's not always possible because of things like other matters, like the target area that's trying to be covered. If it's a line, the best way to get from A to B, but yeah, initially they'll look to not go in an area, and if they do go in an area, then there's additional resilience that the civil engineer, geotechnical engineer, whatever the hazard may be, will factor into the design. It's very much done on it's not a regulated matter, because often there's permitted activity and there's no requirement for a building consent for telco infrastructure, but where the regulation does come in is through the Civil Defence Emergency Management Act, which says that cell phone networks or any telecommunications network and a number of other lifeline utilities must be as resilient as possible to natural hazards, and I understand they're audited under that legislation. So that's where the resilience of the facility to the hazard comes in.
Can you clarify for me? I can't recall whether the point we got to yesterday was that all telecommunication facilities should be exempt from the natural hazards rule, including poles on private land. Was that your understanding?
The way the note's written is it excludes all. I couldn't follow along, unfortunately, yesterday. I was at home with 2 sick kids and a slightly sick father. The poles are really what we're seeking the exclusion for, but it's a catch-all exclusion because that provides the best alignment with the NES TF.
Because the reason why I ask is that under the infrastructure rules, and someone will correct me if I'm wrong, under the infrastructure rules, the poles on private land do require a consent. But I think the recommendation we had yesterday was, for the purposes of the natural hazard section, it didn't need to be covered.
Yeah, I agree with that to a point. I think there is a height. I don't think it's all poles on private land in urban areas that there is a permitted activity threshold from memory in the PDP for network utilities. So heights of, I can't recall off the top of my head, but we would have sought through the submission 5 metres above whatever the zoned height is.
That's right.
So there will be a permitted provision for these poles in the network utilities rules. I can confirm that. I'm not 100% sure, but and obviously the ball's probably in your hands because we haven't had the decision yet either, to a point. I think this would create and we're certainly seeking through the submission to create a pathway where there is a permitted opportunity for natural hazard areas and for poles and the heights through the network utility submission as well.
Good morning, Tom. I'm just wondering about the facility under the pole, like the concrete base of the pole. Can you explain how large that would be, or?
Well, it's almost irrelevant because they're excluded already under that Regulation 57 of the NESTF. But typically in an urban area, there depends on what's attached to the pole, but the cabinets are around 1.3 to 2 square metres in footprint. But as I said, it's kind of a moot point given that they already have that exclusion under the NES.
Okay. Thank you.
Any other questions? Maria, anything from you? Tom, that I think is all we need to discuss with you. I think everything else is fairly straightforward. So thank you for coming online and making yourself available and fitting in with us. That's appreciated. Cheers.
Yeah, no problem. Thank you for your time, and thanks again to Mr. Osborne and Mr. Morris for their ongoing dialogue as well through the process.
Noted.
Great. Cheers. Thank you.
Right. Now that the door has been unlocked, Doyle, if you want to come forward. And thank you, likewise, thank you for fitting in and changing your time. And we understand that you have other meetings to attend to. And so, yeah, we've had a read through. I don't know if you've caught up with the supplementary evidence.
Yes, I have.
Right.
So that was helpful. So I haven't actually prepared a summary.
Okay, so if you use the mic. So yeah, just give us a brief intro on what you see as the outstanding issues, and no doubt we'll have a few questions for you. Cheers.
Just press it, yeah. So I'm Doyle Richardson. I've been engaged by Alliance to assist with the review of the proposed district plan. So I appreciate the opportunity to come along and speak to you today. So yeah, I have read the supplementary evidence that was circulated at the end of last week, and I think by and large I agree with where Mr Osborne lands with the matters that we provided some submission points on, but there is a matter of clarification in there that I want to probably is the main thing to talk about today. I guess just way of a brief background, Alliance is primarily concerned with Rule NH6 and have also suggested some minor amendments to policy NHP9. So Rule NH6 deals with the construction of new buildings, including conversion of existing buildings within areas subject to actual and potential inundation. So that's has an RDA activity status for all of the activities and all non-sensitive activities in all zones, and it's subject to a couple of performance standards, which is the building platform being outside the stream channel and the floor level being above the 0.5% AEP flood design level. And there are some matters of discretion in that rule there as well, and we've suggested some amendments to that to have them reflect, be more like matters of assessment rather than standards. So Alliance's primary concern was with the minimum floor level for non-sensitive activities, and then defaulting to a complying activity if that's not met. The reason being that it could be quite challenging to meet those minimum floor levels where Alliance is located, and we think there should be a distinction between sensitive and non-sensitive activities, or buildings containing sensitive and non-sensitive activities. So it seems, so when I read through Mr Osborne's supplementary evidence, it seems that he agrees that there should be a distinction between the two activities, but then when I look at Appendix A in terms of how that flows into the rules of his evidence there, it seems that there's potentially some words missing off Clause 3 or Part 3 of the...
And what flowed from our discussion yesterday was that the most transparent way of having the rules is actually to split the non-essential from sensitive. And so any comments that you want to make on how you think a non-sensitive rule should be, please.
Yeah. So I guess I'm pretty happy with how the rule is set out as a RDA activity, as long as the building platform is outside the stream channel, and I'm happy for it to default to a non-complying activity if it's if a building happened to be within a building within a stream channel, but I don't think that's likely to happen. But the 0.3 in NH6 has a finished floor level for the new building being above the 0.5% AEP. I think that should be a matter of discretion, or in terms of the assessment to be assessed, rather than a standard that needs to be met for it to be an RDA activity.
So on that, would the matter of discretion simply be the finished floor level as opposed to specifying it's the AEP? Like your matter of discretion might simply say the finished floor level for the new building.
So I'm comfortable with, it seems that 0.5% is a standard that's being used fairly consistently in the rules, so I'm happy for that to be the standard that the effects are assessed against of the whatever floor level they end up proposing.
Yeah, so but that's the difference, I guess, between the function of 3 in the top of the rule and if it shifts down into a matter of discretion, because obviously up in where it is now,
yep,
it's a trigger for activity classification.
Yes.
Yeah, and so once it drops down into matters of discretion, it's functioning differently.
Yes.
Mm.
Yep. So I guess, yeah. So I suppose it would be the effects on people, property or displacement of floodwaters during an event of that size, and similarly the evacuation of properties for an event of that size. So perhaps it could be rolled into those next two matters of discretion. Does that?
But I think that what you're trying to capture, well, presumably we'd still want maybe finished floor levels for new buildings for sensitive activities as a matter of discretion, you know, like that. So what you're doing is saying you, for non-sensitive activities, don't necessarily want that factor in play
As a trigger for being an RDA.
as a trigger for being an RDA,
Yeah.
but it might be something that is discussed during
Yes.
analysis of a proposal. Yeah.
That's right. Yep.
Are you aware of what procedures Alliance has in place for when there is flooding?
No, I'm not intimately familiar. I do know that we had experienced a flood event when I was working there back in 2020 it was, and I don't think the procedures had been that well developed for evacuating the building. Like there just wasn't like really good standard procedures in place. Like it was still dealt with, I suppose, through normal communication, but there wasn't procedures for that. But I can, so I think through these matters of discretion, having that actually set out a bit more clearly would be of assistance to both to Alliance as well, basically.
Yeah.
So that's why I'm supportive of
So you know, what I'm wondering is that whether it's a bit more explicit in terms of procedures available or procedures in place, so that it can be a condition.
Yes.
Saying you've got to have a evacuation policy plan.
Yes.
Yeah.
I think
And
that'd
something
be-
we talked about yesterday, because of the ES evidence, the ES modelling is showing breach scenarios at a 2% AEP event,
Yes.
and saying that the network cannot cope with a 1% AEP. You will get overtopping, you will get flooding. So they were highlighting evacuation in both those scenarios.
Yes.
So
Oh,
one thing
okay,
we talked
yes.
about yesterday was whether the 0.5% is appropriate to be associated with the evacuation,
Yep.
where that might actually be,
A lower number.
yeah.
Yep. Sounds sensible.
So you said there were 2 points. What was the other one?
The other one was
The policy.
just the policy, yes, and the critical infrastructures, I guess, provided for in policy.
Probably need to speak up or have the
Sorry.
mic closer to you so that it gets recorded.
Yeah, it's just an amendment, so it's a minor amendment to policy NHP9, so that it aligns with the other provisions in the plan in regards to critical infrastructure being excluded from that policy.
So what critical infrastructure would Alliance have that's within the floodway?
A hydro scan.
Right.
So I think that meets the definition of critical infrastructure, and it's in the floodway.
Something that I asked yesterday in relation to this policy was whether it's a qualified exception. So you know, we've got other policy that speaks to critical infrastructure and is tying that specifically to functional and operational need, i.e. it's not just that your critical infrastructure, if you're going to be in the Mataura floodway, you're really going to have to sort of prove your functional and operational need to be there. I think it's a bit more than just that you've been identified as critical, and I think the example that you've just given is one where there's, you know, a functional and operational need to be there as opposed to somewhere else.
Yes.
Yeah.
That's right.
So what we've got to do is perhaps reconcile this policy with the other critical infrastructure policy, which is it, what am I looking at? P6. Yeah. And so we were thinking about this in terms of the relationship between the two policies and the relationship with the RPS and what it has to say.
So sorry, is there a question?
I'm just, if you've got anything to add to that consideration, I think you've just agreed that qualifying it with functional and operational need is a yes.
Yes.
And maybe if you have a look at P6 and P9, if you've got that in front of you.
Of the
Appendix A to the supplementary is the one I'm looking at.
6. Yep, that's what I've got here. In at P6 looks okay to me. I don't have anything to add to that.
Is it possible that P6 we might think of as new, maybe, and P9 we might think of as not just new? I guess I'm
So-
trying to work out what each of them are doing, you
Yeah.
know, and how they relate to one another.
So P9 being new, did you say? And P6?
No,
P6 being new and
P6
P9.
looks new,
New.
and P9 is
Existing.
less distinct, so
Yep.
maybe, yeah.
Would that be covered by existing infrastructure?
It might be helpful if Brett actually explains why we've got two different policies.
Yeah,
Seem to be overlapping.
yeah, it does look like there's overlapping, yeah.
To throw you in there.
Yeah.
But I can understand from Alliance's perspective that P9 is achieving what you want it to achieve. So
That's right, yeah.
Yeah.
And the rule and all the other provisions align with that, so yeah, but yeah.
Yeah, so P9 is in there based on a submission from ES, which wanted to expressly exclude or avoid subdivision use and development within the Mataura floodway.
But given that critical infrastructure is dealt with in P6, you don't need critical infrastructure in P9.
Well, P9 was never included initially. It's only come around through Alliance suggesting that it be referenced in there to exclude it because it
Yeah.
didn't want.
But when you look at the confusion that we're both sharing, so you've got
Yeah.
critical infrastructure that you want to avoid it in areas met with natural hazards,
Yeah.
and then and avoid it again within the floodway. Now, I think it's reasonable to say that critical infrastructure should be excluded from areas of natural hazards unless there's functional need, etc. And I think it's equally valid to say that all subdivision use and development should be avoided within the floodway.
Yeah.
I don't think you need to have critical infrastructure twice.
Within P9, yeah.
Yes.
Yeah, I agree.
Is the answer to this perhaps in P6 saying avoid the placement of critical infrastructure, comma, including within the Mataura floodway, comma, da, 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 and then you get the exemptions, you get the unless.
Yeah, but the floodway is part of the natural
Natural
hazards
hazards.
mapped area. So it's a bit like saying a four-sided square.
Yeah.
So P9 was never intended to obviously cover that, and it is to map into the provisions that are at a non-complying activity status for any of those activities occurring.
So then, say a consents planner down the track is faced with these two policies next to one another and is thinking about critical infrastructure, are we confident in terms of how that would play out? I.e., we're in the Mataura floodway and we're critical infrastructure. Are we confident we can rely on P6 to move through the P9?
Yes, because P6 is there to avoid placement of critical infrastructure, and it doesn't identify any particular areas, just all of them. So, by nature, it collects all three overlays. The exclusion of any reference to critical infrastructure in P9 was there just to focus on subdivision use and development, and it's separate from infrastructure. Yeah, so that was my original thinking. Yeah.
Which is, what I was trying to get to.
So
yesterday.
with that in mind,
Yeah.
do you think we need the exception in P9?
No. I think P6 covers it. Yeah.
And then it's a nice, clean, crisp policy that is focused, yes. Okay, that was a helpful discussion, thank you.
Cool. All right. Happy to help.
Yes. All right, so that's probably the key point you want to cover, and
Yes, I'll just check. I'm pretty sure that's it all. That's everything we have. Thanks.
I just want to clarify for my own sake, really. So this is existing, your hydro scheme is
It is.
existing. So, and this is for new development
No.
here?
No.
So, everything. So if it's existing though, you can't then avoid it, can you? Because it's already there?
so that's yeah. But it applies to all use and development. It's not worrying about a little generator. That's quite important.
Yeah. So I think it provides for the existing infrastructure that's there.
Yeah.
Yep.
It's called existing use rights as well.
Yes,
Yep.
that's fine.
All right. So that's helpful. Thank you, Dawn.
Cool.
Enjoy the rest of your day and get
Yeah.
on with your other meeting.
Thank you.
Nice and timely.
Cheers.
So that brings us to an end of people that we're able to deal with prior to 10:30, when we'll be having some input from Shelley. And I see that Natalie's online because we will have some questions flowing. So we're going to have Environment Southland here to hear what you've got to say and ask questions. And there's some issues that we then want to go back to Environment Southland with as well.
So in terms of order, just suggest I start with legal submissions, and then perhaps Ms Hampson could go next so that she can get off.
Yeah.
And then Mr Osborne, is
Yeah.
that okay with you?
I do want to give a brief intro before you speak,
Sure.
just in terms of where we understood we got to yesterday.
Thank you. I've had a great handover from the council team, and also caught up briefly with Mike, so I have got a good understanding, but anything like that would
Yeah,
be much
well,
appreciated.
I think I can simplify yesterday
Thank you
into
very
a
much.
couple of things, having thought about it overnight.
Thank
So
you very
we
much.
will adjourn until 10:30. Thank you, everybody. Do we have a whole lot of piles of paper?